That's with regard to carrying. There is a crime which is carrying a pistol without a license. It's not just simply a pistol, it's a firearm. That is a felony. I believe it's a 5-year sentence, simply for carrying. I believe that is the maximum. Now, if one uses a firearm in commission of a crime, for instance, robbery while armed, that has a mandatory minimum. And if I remember correctly, that's a 15-year.
Yes, you have the 5-year mandatory minimum
For armed robbery?
It's called possession of a firearm during a crime of violence.
Yes.
And if a so in association, the person would be charged with the main crime, which is armed robbery. They would also be charged with possession of a firearm during a crime of violence. That's a 5-year mandatory minimum.
For the first conviction. Well, but the answer to that question is, if a person is convicted of carrying a pistol without a license, that's a felony. If they are convicted of that, they are forever barred from having a gun. They are forever barred. No, I understand what you're saying, but you're asking in terms of the law. So the next time, they're not. I guess I'm losing something in your question. You said a person carries.
Okay, as I understand your question, you want to know why, if someone has already been convicted of a gun offense, they're back again, why isn't there a mandatory minimum associated with that second charge? Not the violent crime that's associated with it, but the carrying of the gun alone. And the answer is, there is a mandatory minimum. What happens is that person is going to be charged as a felon in possession of a firearm. No, I'm talking about right here in the district. No, I'm talking about the local crime. There is a federal felon in possession statute, but there's also one in the District of Columbia. The one in the District of Columbia is actually stricter than the federal one, so we often charge people under the local statute so that we can get more time. It used to be a 1-year mandatory minimum for felon in possession, but it's been increased to a 3-year mandatory minimum. Also, if they're carrying a pistol without a license for the second time, the maximum penalty increases from 5 years to 10 years. So there's a 10-year max if you've carried the pistol without a license on the second offense.
So people are getting CP.
WL.
The second offense on that out of the felony.
I'm sorry, I can't hear what you said.
You said if you're carrying a pistol without a license, the second offense raises the maximum.
Right.
Why are they being charged with that rather than the felony with the mandatory minimum that you mentioned before? It seems like there are too many different options.
I think you might be a little bit confused. The first offense of carrying a pistol without a license outside of your home or place of business is a felony. It is not a misdemeanor. The only time we charge misdemeanor CPWL is if someone has it in their home, and I haven't seen that charged in quite some time. So it is a felony the first time. I also want to tell you about a couple of other changes to the gun laws that we've worked, the U.S. Attorney's Office has worked with council members directly on that have really had positive impacts. The first is the operability requirement of carrying. Yeah, well, just so that everyone knows, it used to be that in order to charge someone with carrying a pistol without a license, we had to prove that the gun was operable. So if the police are chasing someone who has a gun and they throw the gun, which is often the case, the gun hits the ground and it breaks, we can't prove that the gun is operable, so we couldn't charge them with carrying a pistol without a license, and they were getting away. So what the DC Council did was they changed the law. They got rid of the operability requirement. We no longer have to show that the gun was operable. We just have to show that it was intended to expel a bullet by the action of an explosive, and that's easily done. And so that was one positive change. We were able to get a lot more CPWL convictions as a result. Another thing, and a really important change, and I tell you this because I actually charge people with these cases. When the police officers make an arrest, they bring me the case, and I review it, and I do everything I can to try and make sure that the person is charged correctly and that they can be detained. So I'll just tell you about a cars and guns in cars. We were having a huge problem. There would be 4 people in a car with a gun, and no one would be reaching for the gun, so we really couldn't prove whose gun it was. The DC Council passed this new law called being present in a motor vehicle containing a firearm. So that law meant that we don't have to prove that anyone actually had possession of the gun, but they were in the car with the gun and they knew the gun was there. So if I could establish that you could see that gun, that you knew it was there, then I can charge you, and that's another 5-year felony case. So those are very positive changes that the council has.
Hold on. Let me just summarize where we are.